All right, so this is the bond forfeiture docket, Nisi case number 24 DCCV 1018, and I guess these are both kind of similar issues with regard to the same bonding company, correct?
I think they're identical.
And then 24 DCCV 1321. Mr. Kelly or Mr. Romano, what's...
On Mr. Celestine, and again, I think the issues are the same here, is that
From the very beginning, this is more than simple paperwork. A bond forfeiture hearing can cost a bonding company a large amount of money. The real issue is responsibility. When a defendant breaks the rules of release, who should answer for it? The court, the defendant, or the bondsman? The bondsman's main point is clear.
the defendants in each of these cases, in Mr. Celestine's case, he was ordered, I think, by the court to get a drug patch on one setting, given 24, 48 hours, go get a drug patch, come back, or give us notice that you've done so, and for whatever reason didn't. So my interpretation of that is a bond that should have been revoked by the court, not forfeited, or left Mr. Romano and his company responsible.
The drug patch was not included in the original bond agreement. That detail matters. If the court adds new conditions later, it can create confusion about who is legally responsible. This is the gap the bondsman is highlighting. Tension rises because the bondsman feels caught off guard.
That was an issue between Mr. Celestine and the court. I think the issue is the same.
Did I? Well, I mean, if he...
You ordered it in court one day. He apparently showed up to court, and we weren't notified at the jail that he had to have one. So his first day, you showed up and said you need to have a drug patch within 24 hours. It didn't get done. We didn't know it didn't get done, and so the next court date we moved the hearing up, and he didn't show up to court. So that's kind of the issues on both of these.
But if I had, did you not know about the court dates? I mean, regardless of, if there's a bond violation, a lot of times what I'll do is, if it comes to my attention through, Ms. Werner will get the emails from whoever it is that they're supposed to have a GPS or a drug patch. And then if I get some type of referral back from them that says either they're not wearing it, or they didn't get it, or they tested positive, sometimes if it's a positive, I'll at that point just raise the bond and do it at large without proper bond. If sometimes though, I'll, instead of waiting till the next court date for these violations, I'll move it up a week or two. So I guess if I moved it up, which is what it sounds like for a bond hearing, just a review to see what's going on. Are you saying you didn't know about that date?
No, we knew about the court date. What I'm stating here is when we did the bond, the drug patch was not a part of the bond that we did with the client. That was a condition between the court and Mr. Celestine on this actual situation.
Right.
And basically, what I'm saying here is some of these bond conditions are setting us up for failure. I mean, like this guy, you gave him 24 hours to get the drug patch put on. Okay. But he knows he didn't get it put on 24 hours later like he was supposed to. So at that point,
they believe they are being held accountable for rules they were never told about. It's like agreeing to guarantee someone's release, only to later find out new conditions were added without your knowledge. That can quickly turn into a serious financial risk. Then comes another serious issue, the ankle monitor.
Bond should have been either at large without proper bond. I mean, even if we want to do judgment nieces, they can be defendant onlys, because we're the ones getting punished here for bond conditions that when we post these bonds at the jail, we don't have much to know about. I mean, the next guy violated 18 times bond conditions that we didn't know about until the day of the hearing that he forfeited on.
Yeah, may I respond?
Yeah.
There's a couple of things. Number one, if the bondsmen want to know what conditions, what changes are being made here in the courtroom, they should attend the hearings. It's not appropriate for the court to.
Well, let me stop y'all. I think the conversation that we need to have is probably something that we need to have maybe at a bail bond board meeting, where we can address if and how those conditions can be relayed when we do them here in court to you guys. But that's the thing, is that's every court does it differently.
Yes, ma'am.
But the court date and the bond forfeiture it is what it is. I mean, they didn't show up. You're not saying you didn't know about the court date. And so I think regardless of why I set something, whether it was because of a bond issue, that to me, we're talking about two separate things. Somebody didn't show up for court because of a violation of a bond condition, but they didn't show up for court. So that's a forfeiture. If I know, it's just different on how, it depends on, for me, how I handle them. And we can talk about that later.
So on the next one, the state even filed a motion to increase or revoke. We set a hearing for that. He had violated 18 times. We didn't have any notification from the ankle monitor business. And we have no grounds to drop him when he is violating those conditions.
No, I understand that y'all might need some type of, I understand.
So I'm asking some kind of relief because this next,
Well, I don't know that I knew someone violated 18 times.
I didn't say you did.
No, I'm just saying, I don't know that either of us
Yeah.
knew that. Because if someone's violating an ankle monitor 18 times, typically it's going to
Somebody's-
immediately be at large without proper bond, not just let's reset a hearing for a week out, because I would be concerned about that. So sometimes we may not get it from the company until they say, oh, look, there's been a whole lot of these. And so we don't know that either. So that's obviously something we need to take up. I guess,
There were 18 reported violations, which suggests repeated failure to follow the rules. But here's the problem, neither the court nor the bondsman seems fully aware of these violations. That raises an important question. Where did the breakdown happen? Was it the monitoring agency, poor communication, or a gap in the system?
Governor, if I might respond.
yeah.
Section 2213 does not list the court changing bond conditions as grounds for exoneration on the bond. I mean, it's simply not there. I mean, it's the court has to address the defendants as the defendants appear in the court. The bond conditions for the jail. Right now, Mr. Romano has not told the court that they can't go over to the jail and pick up a copy of the conditions that are placed on them at that time. I don't know why they're not getting communication from the
Well, no,
ankle
he's
monitors.
getting them, they're getting them
It's fixed.
when they're initially done.
yeah, it's fixed now. That issue.
That's been,
Okay.
yeah, we've been working on that.
Otherwise, they
But
can
what
attend
he's
here.
not getting is their information here. And I understand that they can't also be in every court every morning. There's, I don't know how many people they have working for them, but we've got 4 or 5 courts going on. So I understand that there's an issue potentially with getting that information. I don't think it changes legally, though, the fact that there was a court date, knew about it, the defendant didn't show up for that court date. And so I don't think legally there's relief necessarily that I could give unless there's some agreement to that. I do understand where you're coming from, but I think the fact that y'all knew about the court date, it wasn't some communication issue with knowing that he had to be here, or both of them were guys, that they had to be here, and that it didn't show up. I understand what you're saying. If you knew that there were those violations ahead of time, maybe y'all would have filed an AFRS or whatever.
That's part of what my thing is. We can't. We do bail bond agreements with these people, and it spells out what grounds we have.
Right.
So these violations have to come from the court as far as the issuing of warrants, and I can't even go rearrest them. We have a investigations company, but I can only go pick up on our forfeitures. So even if we do an at-large, my hands are tied on some of this. And Mr. Price just wants us to keep going after these people, and I understand that. But even on this kind of situations, I can't go after these people. I can't even issue a warrant for them. Legally, I cannot, because they could come back at us and go, well, here's what our contract says. Well, the bond conditions were not part of our bail bond agreement.
Well, what if, we need to talk about that later too. Make a note, because why can't y'all put in your bond agreement that it's any bond conditions that are there and any bond conditions that the court orders?
That would be something we have to do after the fact. So sometimes, like now, we're knowing bond conditions. This isn't an issue that's going to keep coming up because they fixed it at the jail. But this is some of the old stuff that we didn't know until we get blindsided.
So were these my conditions on both of these, or were these conditions that were, because I think that is different. If these were conditions that were placed by the magistrate at the jail, or were these conditions that were placed on them here in court by me?
I'm sorry, Judge, on Mr. Celestine, I believe that was the court's
Yeah, that was the court's.
on the drug patch.
Okay.
These were the court's standard conditions because they're
One's a
general
felony.
violations anyway.
Mr. Ortiz, I think, is gonna be, yours also.
Okay, so these weren't the jail issue. Okay, all right, then I'm going to, grant the forfeitures, in each case, and then we can discuss, somehow if, I get with all the courts though, to figure out a way to get bond conditions that are placed on them after the fact by the court, which happens all the time. And so I don't know, really, other than y'all being here, but we can try to work something out. But I don't think that's necessarily, the issue's gonna be getting everybody to do with the same, but we can talk about it at Bail Bond Board, all right?
Your Honor, just for clarification, I would ask that the court take judicial notice of the court's bond forfeiture docket for the cases thereon,
We'll do so.
and take judicial notice of the bond forfeiture case and the underlying criminal case in each of those,
We'll do that as well.
and enter judgment according to the court's docket.
I will do that as well.
We have final judgments prepared for that, Your Honor.
Okay, thank you.
Thank you, Your Honor.
All right, and hey, remind me, and we'll try to figure something out.